A full Supreme Court bench comprising 5 judges heard arguments and submissions in a case brought by independent presidential candidate Dr. Panduleni Itula and others seeking the court to nullify the outcomes of the 2019 presidential elections. Jeremy Gauntlet, the lawyer for the applicant in the Supreme Court challenge against the use of electronic voting machines in the 2019 election, said the elections using EVMs without a verifiable paper trail can simply not be considered free, fair and credible. He said India, Germany and Kenya overruled the use of EVMs without paper trails as it lacks the ability for checks and balances. The applicant submitted that if the court finds their argument to be legitimate, it should order a fresh election regardless of costs and implications. The lawyer also took issues with the Minister of Urban and Rural Development's selective enactment of the provisions of the Electoral Act, saying that should be declared unconstitutional. In his counter-argument, defense lawyer advocate William Mokari submitting that the Supreme Court is not an appropriate avenue for the applicants as the Supreme Court is reserved for appeals. Hence, the court does not have jurisdiction over this matter in the first instance. He suggested that the Supreme Court be reluctant in claiming jurisdiction over this matter and should rather rely on the wisdom of the High Court. The defense also argued that the applicants knew about the Act since 2014 and hence it was at their own peril that they unduly delayed seeking remedies promptly. The applicants' delay, he said, prejudices the respondents, the public and institutions, hence his prayer that the court should not entertain the matter but should strike it from the court roll. South Africa's Mokari further stated that the fact that EVMs were used in 2014 without being ruled out by any court gave the ECN the courage to conduct subsequent elections under the same conditions. Judge Baetse Nkabinde reminded the defense lawyer that the case at hand deals with a constitutional matter which the applicant wants protected. She questioned whether the minister's selective putting into force of the Act was not in violation of the Constitution and whether it could be considered to have been done in the interest of justice, public institutions, or the people of Namibia. Chief Justice Peter Shivute and Judge Nkabinde grilled the defense lawyer, asking him whether the minister should not be seen to have violated the Constitution through selectively enforcing and omitting subsections of the law, which was passed by Parliament and signed into law by the President. I'm Daniel Nadunya, NBC News, Windhoek.